So I'm going to have to ask you also to introduce yourselves. So can I start with you, Maggie? Thank you very much for being here. If you could just tell us a little bit about your background as an attorney, and all your various things, and your interest specifically in this whole class action thing with Anthropic.
Absolutely. So my name is Maggie Marr, and I'm the founder of Maggie Marr Legal. My background is I was a former motion picture literary agent and then started my intellectual property law practice dedicated to creators. I have a number of clients are involved possibly in the settlement, the Anthropic settlement, and getting a lot of questions on that. I also am a USA Today bestselling author. So.
Fantastic, thank you. So yeah, from lots of different perspectives there, you will be able to jump in and talk about this topic. And we were originally going to get Catherine to do the intro, but she's coming a little bit later. So I'm hoping you'll be able to take over that role for us and fill people in about, you know, what all this is. I'm assuming that most people who are in the room have an interest and are already a bit clued in, but I want to say that this is just one tiny part of what ALLi is going to be doing around this issue. So don't worry if you're watching this in replay or you're watching this live and you're thinking, I'm not getting it, I don't fully understand it, you know, I have questions, because we will be putting together a full briefing document which will refer to both this this event, but also other things that have been going on a little bit in the background. But we really wanted to do this event because a lot of US authors are very clued in, but this does not just apply to US, and we were keen to have people from other parts of the world as well. So Dan, maybe you could pick up and talk about where you're from, and obviously as ALLi News editor, you've been following this story very closely, but also your particular interest if you have one around this whole topic. No, his audio is not coming through. I'll just jump to Anna, Anna is also here really partly representing the you know, other countries, the idea of overseas people being able to avail of this also. So Anna is coming to us from Australia. Thank you so much for being here at this time.
Yeah, well, let's hope I'm coming through. Am I coming through?
Yes, you are.
Awesome. So no tech gremlins. So yeah, I'm Anna Featherstone. I'm ALLi's nonfiction advisor and also an ambassador down here in Australia. I am a judge of the Australian Business Book Awards, a publishing consultant for the Australian Society of Authors, love doing workshops for like Writing New South Wales, and just my life is books and authors, and obviously copyright matters so much to us because it's our intellectual property, and I'll bring a little bit about what's happening in Australia at the moment.
That's fantastic. Thank you so much. And questions too, I think, will be coming. You know, we're all learning with this stuff, and it's not something that as authors we ever expected to be getting involved in. And so it's very much in the learning phase. This is, I don't think, the last we're going to see of class actions or of various legal movements around this whole arena. So, you know, we're playing catch up to some degree, and that's been a very deliberate move by the large tech corporations. We are on the back foot, but we are on the move, and history shows that when authors get on the move and get together, that things happen. So Maggie, could I ask you to, I know you've prepared slides for us, could I ask, are you able to share them? Do you need my assistance with that?
Yes. Did you want me to do a little background on Anthropic since we're missing one person? Just a tiny little bit?
I would okay. Very, very much like you to do that. Please do, yes.
I pulled up some information that I utilized when I gave a presentation for ALLi not too long ago. So forgive me, I'm going to read it so that it's clear and accurate as opposed to just winging it. So this is what I have.
Legal.
Yeah, Bartz versus Anthropic is currently one of the most important copyright lawsuits brought by authors against an AI as it relates to the use of books without permission to train language models. So the company did not seek permission to utilize these books to train large language models. It was filed by nonfiction authors Charles Graver, The Good Nurse, and Kirk Wallace Johnson, The Feather Thief, and thriller author Andrea Bartz, We Were Never Here. It was scheduled for trial, but the parties entered into mediation. The settlement agreement was preliminarily approved by Judge Alsup on September 25th, 2025. In June 2025, Judge Alsup of California ruled on summary judgment that using books without permission to train AI was fair use if they were acquired legally. But he denied Anthropic's request for summary judgment related to piracy, finding that the piracy was not fair use. Judge Alsup scheduled a trial to determine Anthropic's potential liability for piracy for December 1, 2025. However, in July, the court certified a class of all rights holders of the books that Anthropic had acquired from LibGen and PILIMI, provided the books were registered with the U.S. Copyright Office in a timely manner and have ISBN or ASIN numbers. Judge Alsup certified the class only for piracy, not the act of AI training. And as such, the fair use ruling on training applies only with respect to the three named plaintiffs, not the certified class authors and publishers. The proposed settlement agreement came after an arm's length mediation with a neutral third-party mediator. The settlement agreement was preliminarily approved by Judge Alsup on September 25, 2025. I think it's really important to understand that there's no ruling, right? The judge did not rule that Anthropic could not utilize these books, that what they did was illegal, right? He didn't rule in that way. So one of the things I think it's important for authors to understand that the settlement agreement, I believe if I've got my numbers right, is for $1.5 billion. So in my opinion, and in my experience, when a corporate entity enters into a settlement without a trial for $1.5 billion, that probably means that they realize their liability is at least 3 to 10 times that, right? Based on what they've done. So by agreeing to this settlement, and I'll show you my slides, how you would agree to this settlement, it may preclude you. And keep in mind, I don't litigate, I'm not a litigator anymore. So, but it could preclude the authors who agree to the settlement and the claims within the claim within the settlement from suing Anthropic in the future. And I do not know how it will relate to other tech companies or tech companies that license from Anthropic the AI that they've created. So you may be cutting yourself out from future claims or the ability to sue for the fact that they were infringing on your copyright without a license. And also, I would assert, in my opinion, just my personal opinion, this is not an unusual style for some of the newer tech companies where they will, they want to move quickly. And so instead of asking for permission, they will just move quickly and then beg for forgiveness later and pay whatever they need to pay to keep moving forward. So this is the website with regards to filing your claim for any titles that you may have that would be part of the Anthropic settlement. And this is the landing page that you will get. Welcome to the Anthropic Copyright Settlement website with the question, are you the legal or beneficial copyright owner of a book included in the Anthropic Copyright Settlement? When you press the button to file a claim, you have the ability. There's also, if you take a look at the top, it says works list lookup, and you can look up by your ISBN, I believe ASIN as well, and you can look up by name. I can tell you that to file the claim, generally you're going to have to put in each individual work, and you may want to go ahead and do that. So file a claim. To file a claim, please enter the unique ID provided in the settlement notice. You don't have to have your unique ID. You would just press the button, I don't have a unique ID, and then it will lead you through the steps to file your claim. And it does require all of your claimant information. with regards to your work and who you are. And again, this is just the first phase. And I believe, if I'm remembering correctly, I think the proposed payout right now is either $3,000 or $5,000 per title that is listed. And this is information if you ever need to get a hold of me for anything. So let me see if I can get back to that. A couple of things that oh, go ahead.
Thank you. Yeah, go ahead. Sorry, I didn't mean to interrupt. I was just thanking you.
No, I think a couple of things that are important is that they are requiring that you had filed for a copyright before the settlement, right? So you would have had to file for copyright for each one of your lists. That's how they're confirming those titles. So.
Yes, I think this is an important point. There are a couple of important points to be sort of teased out, but I think perhaps we'll just rest that there for a moment and we'll come back, because I think, you know, authors can be getting really excited and thinking, what, 3,000 per title? And this, you know, this is better money than I made last year selling my books. But it's, you know, legal cases don't tend to always turn out the way we're at the very, very, very early stages. But I'm delighted to say that Catherine is now with us, Catherine Goldman. Catherine, I had a little crisis before we came on. I stood in my glasses, so I could just about barely see you, and I can't read your bio for the nice people. So can you just tell people, though, a little bit about yourself and your interest in this case? You know, what you're finding so interesting about it.
Sure. So I am a copyright, trademark, and internet law attorney. And I have been representing creative professionals for many. We're working into decades now, right? What I try to do is I try to help creative professionals protect their creative work so that they can go out and profit from it. I have been following AI since, I guess, 2022 is when ChatGPT came out, and I've been following all of the litigation. I've been blogging about the litigation and writing emails about the litigation. And so I just find it super exciting. I think AI is one of the most exciting things that has happened in my career as a copyright attorney. And so I apologize for all the people who think that, you know, the world is going to come to an end because of it, but I just think it's fun. So having said that, so that's me. You can find me at thecreativelawcenter.com.
Okay, Catherine. So Maggie has just given us a very good sort of brief overview. We've seen the website that authors need to go and register on, and just to fill you in a little. And we also, you know, we were just beginning to get into the discussion about who is eligible and who is not eligible. And this is a case that's being taken in the US courts, and so US authors are particularly strong here in that you have to have registered your copyright with the US Copyright Office in order to be eligible. Now, there seems to be slightly different information coming through on this. So yeah, I'd be interested to hear you guys about that, the requirements. Anybody who's registered up to the point, what point in time is the cutoff for registration? Do you want to take that one, Catherine, as you've just joined us?
Yeah, sure. So the cutoff. So Anthropic downloaded from two separate pirate sites, okay? And they did it in let's see, I think they did it in June of 2021 and July of 2022, okay? And so your book, your title had to have been in one of those data sets at that time. and you had to have registered your copyright at the time of the download. It had to have been registered before Anthropic accessed those data sets, or within 3 months of publication of your work. So let's say, you know, you published in I don't know, May of 2021, your book got into the pirate site, Anthropic downloaded it, and then in July of 2021, you registered with the Copyright Office. You would still be covered even though you registered after the download. So that 3 months after publication is a magic number in the US copyright law. So, and it's not just, as you mentioned, it's not just US authors, it's any author who has published or sold in the US, regardless of their citizenship. If they have filed with the Copyright Office, then they're entitled to that protection if they're found in that data set.
So it's really very interesting because, you know, up to just about a couple of years ago, ALLi advice was, you don't need to register copyright. Copyright is yours from the moment of creation. You know, and that has always been the sense here in the UK. I think I'd be right in saying Australia too, Anna. Yeah.
Yes, definitely.
It was it was only in the US that you had this extra layer, if you like, on of copyright, which was register with the Copyright Office. And then there was the judgment, there was a previous judgment whereby, I forget the details of that case, but again, the judge very much said, you know, if your books are registered for the Copyright Office, yes, but if not, no. So we began to change our advice to our authors and our members and say, yes, it looks like, you know, if you're in the US, certainly you should register. And now this, it looks like everybody should register, because this isn't going to be the last case, is it? This isn't going to be the last class action, or it isn't going to be the last thing we're going to hear about all of this. I mean, Anthropic is one company. There are so many companies now. So yeah, would you like to kind of just pick up on that a little bit, Maggie?
Well, I was going to say that copyright is automatic, right? Like you have your copyright in the EU, the US, and the UK, but in the US, there's always been additional protections once you file for copyright. So it's always been kind of in the best interest of an author to always go ahead and file with the US Copyright Office. It shifts the burden of proof. It allows for attorney's fees and statutory damages. And I agree with you, now moving forward more than ever, I think this will not be the final. And in fact, I would assert that at some point, there may be authors or a class of authors that have litigation with regards to not having filed for copyright, but yet still their copyright was infringed, right? So there, that is a potential case as well, you know?
You're nodding furiously, Catherine. Do you want to add to that?
Well, I just feel that because there are so many countries, or all of the countries, unlike the US, where, you know, your copyright is immediate and there's no necessity for registration in order to enforce, that just because this particular case has determined that there needs to be a copyright registration, that is not necessarily precedential. What I don't know is, I don't know about the status of class action law internationally, right? I know that it's very strong in the US to get a class. But it strikes me that you should be able to file a class action suit that would apply the law of the UK or the law of Australia, where authors have immediate copyrights without registration, right? So what we had here was US venue, US jurisdiction, and US law. Well, we can have US venue and UK law. That happens all the time. So I think, Maggie, you're correct. There is going to come a time where there's going to be a class on behalf of those authors who found themselves in pirate data sets and who are going to be, whose rights are going to be protected in the future. I think it's going to happen.
And then
That's
the other
really
thing,
interesting.
oh, I'm sorry, we mentioned before,
No.
which I think is super important, Catherine, you'll agree, is that this is not a ruling. This is a settlement,
This is a
right?
settlement.
Nobody has ruled on this. And one of the things I mentioned before is that I think authors need to be aware that if they participate in this specific settlement with regards to even a subset of their titles, they may be foregoing the right to participate in any other lawsuit if it has to do with the same sort of AI that was created by Anthropic, right? I've not seen yet what exactly an author is going to have to sign or agree to with regards to participation in this settlement. So I do think that there are some strategic things that some authors, maybe with a big body of work especially, may want to consider before accepting the settlement.
Well, that's an interesting
Yeah.
point. You know, Orna, if you get your hands on the actual release document, I think Megan
Trying.
would both love to see it, right?
Yeah.
What is it that you're giving up? So that's a great point, Maggie.
It's very, very, very important. And back to the point about class action elsewhere, class action is not really something that happens here in the UK. It's something that's very, really quite common in the US, but it's not something that happens here. And I'm just wondering about Australia, Anna. Are you aware of class action? Is that something that Australian?
Yeah. Australia does have a couple of class actions, like nothing like what happens in the US, but I suppose it's probably the right time to say this now, that our Attorney General is actually in talk with like tech groups and rights holders on a licensing framework. So the Australian government very recently came out and decided that no, they would not carve out like permission for AI companies to do what they want. So there was a lot of advocacy work done. So they're now looking at forcing big tech to reveal the copyright material used to train AI. And they're looking at maybe a small claims regime, so rights holders could sue for copyright infringement without having to launch court cases, like expensive court cases. But everything's in flux, as you can imagine. We don't know where things are going and what's going to happen. We're also down here, they're looking at like a collective licensing framework. So AI would be forced to have licensing agreements. So, but as we know, like some of the AI, they're not adhering to the laws of each country currently. So a lot is to be revealed, I think, over the coming days and weeks and months and years. But there has been all the artists in Australia came together. So we have musicians, writers, and had a big powwow down in Canberra, like the capital, with a lot of the politicians. So at least they stopped that carve out for AI companies. Yeah, we'll talk a bit more after.
Maggie, yes.
I was going to say, when I was doing a little bit of research for my last presentation on this, what was interesting to me in researching primarily the UK, Europe, and the US and how they're trying to navigate this, and also looked a little bit into India. The real balancing act, I think, for a lot of governments is acknowledging and wanting copyright holders to receive remuneration for their works, but also not wanting to be left behind in the technology, right? There is a real fear, I think, or concern in many governments that if they become too restrained with regards to this new technology, that they could be left behind, and that would impact their entire society and their ability to be participatory in this next century, right? Like, it's a true, nobody quite knows where it's going to land. And I think it's the UK that has the ability, you can opt out, but you have to proactively do it to opt out of any AI tech company utilizing your work. And I believe that there's some challenges with clarity of exactly how to do that for creators in the UK. Now, I don't practice in the UK. This is just from my reading. But it is, Catherine, you're right. It's so interesting. It's like the wild, wild west. You know, there's not an area of law that is so up in the air like this, to my knowledge.
No, I mean, it's just people now are using the word copyright in full sentences, and
Right.
and years ago they clueless.
Right.
So it is going on. But I do want to clarify a couple of points, and then Orna, if you want to get us back on track. But there was a ruling in this case about fair use, and so and one ruling said that the training of the AI machine on the materials was fair use, okay? But that the downloading of a pirated data set was not fair use. Now, I found that extraordinarily interesting and probably wrong, but I think that what we haven't seen is the expert testimony on which the judge was informed with respect to that ruling, A. And B, in the Anthropic case, they did not focus on the output at all. And they didn't they weren't able to show that the output was in fact substantially similar to the underlying works that were used to train the AI. In the visual arts cases, they've got output that is substantially similar. So yes, this is still moving. But you know, to the other point that was made, in Australia, they're putting together a licensing scheme. I think that this Anthropic settlement is an impetus for licensing schemes to be developed for written work, much like they exist for photography and images and for music. So I think that we're going to see that. We already know that there are people working on that. So I think that that's what's going to happen, which is great.
I think so too. And I think, you know, we already have models that it can just slot straight into here in the UK. I wish Dan was here because he would be able to fill you in on some of those questions you had about the UK. Maggie, I'm very aware of the opt-in, opt-out thing. Obviously, we, like other pressure groups, are, you know, we want people to be able to choose to opt in, not to have to opt out from something you don't even know has been done. I mean, it's just completely unfair. But we have the ALCS here, the Licensing and Collection Society, who collect for all sorts of what you might call micropayments for photocopying, and lots of small, you know, returns like that. And I think when all of this settles down, that's probably what we will be looking at, not thousands of dollars per book. And I think I worry slightly about the numbers that are being bandied around and authors thinking that they're going to, you know, make money from this, because my experience is that it doesn't usually pan out that way. It makes, you know, we're in the very, very, very early stages. So I suppose what I'd like to focus on now is, what should authors do right now? Let's say US author, overseas author, is there anything to be done? It's, you know, this particular boat has sailed, but given that, you know, this is just one little dinghy in the middle of a whole fleet. What do you think authors should do in order to put themselves in the best possible position? Yeah, Maggie, will you go first?
Okay. Well, first of all, I know a number of authors that have big bodies of work. And if you were to say to them, do you have a list of all the titles you have published or written? They might not be able to have that. So even taking sort of an audit of your own work with regards to articles, anything that you've created, books, audiobooks, ebooks, paperback, especially big independent published authors, right? This is not uncommon that you could have one book and several derivatives that you've created. So I would do an audit of the work that you've created, right? And then the next thing I would say is that if you haven't filed for your copyrights, go ahead and file for your copyrights. Now, Catherine, you may disagree with me on this, but I often will say to an author, if you can write a book, you can absolutely file for copyright with the U.S. Copyright Office, right? Like it's not.
It's
so
a
challenging. It's a challenging website, but you can totally do it, right? You just got to sit down with a cup of tea or a cup of coffee and just file it. And I do have clients who will say, I don't want to do it, just do it. But an author can definitely file for copyright. Now, as of this week or earlier, no, last week, the U.S. Copyright Office website was down for filings, and that was because of the government shutdown. I am hopeful it will. I'm not sure. I haven't checked it today, but I'm hopeful it'll be up again soon. Because that has delayed our office a little bit with some copyright filings. But file for your copyrights, right? Because then you will have them in hand. And as we move forward with this, at least you'll always have that. That would be my piece of advice.
Yeah, I mean, having your copyright registrations is useful for a lot more than just fighting off AI companies. I mean, it really helps with estate planning, for instance. And, you know, just it makes a lot of sense. For those of you who have large catalogs of work, you know, you're going to want to triage that catalog, and you're going to want to choose which ones to file first. And I agree, Maggie, completely. Authors can file their own copyrights. In fact, their assistants can file for them. I mean, it is not. Once you do it, you can save a template, you know, I mean, it is something that you can do online and you don't need a lawyer to do it. Although some of my clients, like yours, want me to do it for them. So, so you have to triage your catalog, figure out what needs to be, what's the most important work. That the work that's getting stolen the most should be you should file for. The work that's making you the most money, you should file a registration for. And so, you know, try and figure those things out after you do your audit and put your catalog together.
Great. Any tips or thoughts, Anna?
Yeah, I suppose like with the UK as well, we always thought our copyright was protected, so we didn't have to also register in the US. But now, obviously, that does change now for people to actually have to consider registering with the US as well.
Yeah, because so many of the tech companies are headquartered there, and you know that's where the cases are going to be. Most of them, or many of them, are going to be decided, I think, because it's because of that reason. So yeah, I think it's getting.
Yeah, that's the thing too, like that whole late registration. So if you didn't register years ago, is it still worth registering now? And it seems like, and over to you guys, but it seems like even though it might not mean you'd be eligible if you decide to go in one of those suits, it still might be worthwhile, even if you're 3 years later than you should have been. Is that correct?
I think so. What do you think, Maggie?
I agree. It's a copyright is an asset, right? Like it's a chain of title document. You know, I think when authors and creators spend a lifetime creating a body of work, they should have that document. That document can be really important, if not just for them, but for their heirs, as Catherine pointed out before. It can become hugely important. Yeah.
We've also found it useful in terms of proving copyright to KTP and other platforms where there has been a dispute about rights. It's the quickest and easiest way is if there are other ways, but the quickest and easiest way is if it's been registered. So much as it pains me, and I have to say it does, because I really liked that idea of, you know, your copyright is yours and it's guaranteed and it's assured and you don't need to do anything else. I think also because this is only one case, you know, there's going to be more stuff coming down the track, and for that reason, you know, if you register now, you may be eligible for the next one. Though, as Maggie says, we're all going to have to look at the small print and see what it actually means and what it actually turns out to be.
Yes, because you might not want to actually be in that suit. Like you might want to wait for to see what else plays out.
Exactly.
Well,
exactly.
You know,
and the small print, as you two know so well, it's all in the small print. Yeah.
So the class definition for this settlement class is specific to folks in that data set at that time who have copyright registrations that were properly filed, right? So if you're not in that class definition, then you are free to participate in other actions that might come up. But still, I do think you should get those registrations. If you intend to enforce your rights in the United States, that registration is going to be required. And as you mentioned, Orna, KDP, boom, makes it so fast, right? Here's my registration. It just makes it so fast. Enforcement, Facebook infringement, you know, Google takedowns. I mean, having that copyright registration is fabulous. And there is no time limit on it, filing an application for registration. The remedies change over time, but you can still, even if it was, I mean, I've had clients who have inherited work from their parents and have filed 20 years after creation of the work.
Okay, that's an important point too. Thank you. Anna, could I ask you to look through the chat and see if there are any questions there, because I can't see if there are questions there that need answering that
Sure.
would
Well,
like to.
Yeah, ALLi asked a great one because, and we've kind of gone through it, but she asked how much does it cost to register with the US Copyright Office, and Linda said yes. So the standard is 60, single work 55 US, standard 65, or something along those lines. So I mean, it's going to add up if you have a number of works. And also, if copyright is determined at the moment you create, publish, like everywhere else around the world, what she's wondering, why should we need to continue to have that protection in the US too? Well, why would we not have that protection? I think you've kind of explained that now. That
well, I think that there's a possibility that there could be another class action out there that covers authors whose rights are controlled not by US law, right? So I think that's a possibility. I'm not aware of it right now, but I think that's a distinct possibility.
And real quick, I wanted to add that it's not that, so when an author writes a book in the United States, they do have their copyright and they keep their drafts and they can prove that the copyright is theirs. But what happens is that when you file with the US Copyright Office and you get your registration, it provides additional protections. And I mentioned this before, and maybe I should explain it. One of the biggest ones is that it shifts the burden of proof. Meaning that if you find somebody has copied your book and put it up and is infringing on it, you no longer have to prove that that book is yours as the original author because you have your copyright registration, right? That individual would have to prove that you fraudulently registered for copyright, right? Like, so it gives you additional protections, and the statutory damages and the attorney's fees can be really helpful to an author when they want to find a litigator, an attorney who will litigate the action, because being able to know that you're going to have a minimum in damages as well as be able to recover attorney's fees. Attorneys are expensive, and litigators are even more expensive than transactional attorneys, right? So that can help you to find a litigation attorney who's willing to take on your case. So these are added benefits by proactively filing for copyright.
Thank you. Whereas if you are the
I might have missed one. So.
Pardon?
I said, did I miss one? I might have missed one, but in my mind, those are the additional benefits.
Oh, yeah, no, absolutely. And that is probably why these sets of attorneys took this case. And that's why it's limited to people who have registrations, because there are attorney's fees. Now, and just on that note, and Orna, you keep saying accurately that it's early times and we don't know how much money they're going to get. Well, that all this 3,000, 5,000 number that's getting bandied about, that's before attorney's fees and costs. And the settlement has capped attorney's fees at 25%. Okay. And so let's say it's $3,000. Well, minus 25% right off the top going to the attorneys. Now, the attorneys are getting 25% of 1.5 billion. So they did okay. And the reason they did was because of the registrations. So,
yeah.
Orna, I do have, I don't know if I can share my screen. I have a slide with critical dates that I think would be important. Unless
Fantastic.
You went over it. Did you go over it already?
No, please do that. That'd be great.
Okay, all right. So these are the dates that we're operating under right now. September 25th, the settlement, there was preliminary approval by Judge Alsop. November 24th is when plaintiff's counsel must give notice to the class members of the settlement. And that notice will contain all of these dates. The notice has to go out by first class mail to everyone in the class that they have that information for, email, and then they're doing massive advertising, and that's why we're talking about it right now. January 7th is the opt-out deadline. So class members can choose not to participate and to pursue litigation on their own. Also, January 7th, class members can object to the settlement, but they have to have a reason for it, and they have to tell the judge what that reason is. March 23rd is the claims deadline, so everybody has to choose, well, they have to file their claims by that deadline. They have to choose to opt out by January 7th. And then right now, the fairness hearing is scheduled for April 23rd. And the judge will hear the objections and the arguments in support of and against the settlement. And then if there is a final approval at that time, there is, of course, an appeals process for those who have standing, which may be someone who filed an objection. And then once the appeals process is concluded, then the payment process begins. And that payment process is spread out over 2 years. And that April 23rd date might get pushed. But that's what we're looking at right now.
That's very useful. Thank you so much. That's great. Anna, you were going to say something there just before that.
Yeah, just for the Australian authors out there, we have an amazing copyright office in Australia as well, where you should be listing all your work. So magazine articles, anything that you write that may potentially be photocopied as well as copied or reused in any kind of setting, like maybe a school or a government office. And every year they pay us authors money through these licensing schemes. So
Wow.
yeah, so if you haven't already, as an Australian author, listed all your works, from articles through to your books, pop into the Copyright Office website and do so, because it's an amazing scheme that supports us authors, and they, along with the Australian Society of Authors, are doing some amazing advocacy work in this space. And I mean, it's just wonderful every year just to get a check, or money straight into the bank account from the Copyright Agency for our works. So definitely get on board with the Copyright Agency, and there's no fee to be involved for you to do that.
Why can't we do
to
that in the US?
Well,
Right?
also in the US,
You're
you
too
don't have
litigious, and now you're making the whole world litigious.
I know. So yeah, for other authors out there, and Australian authors, if you sign up for lending rights in Australia, and we also get paid every year for our books being in libraries as well. So
Same in the UK. Same in the UK.
Yeah.
Through
But it's
that
definitely
collection
worth
society.
registering and
Yes.
getting those things. And one other thing I just wanted to mention too. So, if your book was caught up in this LibGen data set, so when I go and search on my book in the settlement, or a number of my books, so nothing comes up. But then when I go to the Atlantic, who did an original investigation, and they have a database, you can look up what books are in the LibGen data set. So one of my books does come up there. And so I think they're advising just take a screenshot of that as proof that your book was scraped and is, in that other data set, because that may be helpful with future claims as well.
Right. Very good. And just to reassure listeners again, all of this will go into, we'll be putting together a pack with the instructions, advice, make up your own mind, obviously, but with the various recommendations and tips that are coming up in this session. So don't worry about having to write everything down, or you didn't hear everything. And yeah, I think no matter what country you're in, check out the Copyright Office or Collection Society or whatever operates in your particular jurisdiction, because as indie authors, we are the publishers and we are the business, and so we need to do that work. Nobody is there doing it for us on our behalf. So if you need any assistance with that, as ever, if you're an ALLi member, just write to the member desk, info@allianceindependentauthors.org, and we'll be able to assist you with that if you don't know where to go or how to find out. And we'll be outlining the whole picture. What we're going to try and do is something similar to what we did about the taxation for ebooks in different countries. So we're going to sort of you here in relation to the US if you're overseas, or you here if you're in the US, what applies for you outside. Because at ALLi, there's no such place as abroad. We live online. So our members are always in a slightly different mindset than members who are working with their local, though we recommend that as well, working with their local associations, which will be territory based. Okay, so any last thoughts before we wrap up? Yes, thank you, Catherine. Yes.
So I do want to point out to folks who believe they are in the class, if they are class members, that there are already reports of fraud concerning the settlement. And so this was reported last week, that there are these unauthorized third parties, and they're posing as legal advisors and representatives, and they're trying to convince class members to opt out of the settlement, and they're spreading misinformation, and they're misrepresenting the terms of the settlement, and they're misrepresenting rights. In some cases, they have used the Author Guild's name. And I think that perhaps, I don't know, Orna, did the plaintiffs' counsel reach out to you to tell ALLi about this fraud that's being perpetrated? So I think that everybody really needs to be careful that they are using the website that Maggie showed us at the beginning when they are making their claim, and if they are talking to people who are not from that website or the two law firms that are handling the case, to double check before you make any irreparable decisions about your claim.
Fantastic. Okay, well, thank you all so much. That was really great in terms of setting the scene, and I'm sure it's not the last conversation we'll be having on this topic, but it really gives our members a fantastic sort of baseline to understand what's going on, and that there is no panic, there's no rush, they're not missing out, they're, you know, just take it easy. There are some decisions to make, and there are, you know, you've been given your dates, you have your marching orders. You should by now, you know, at the end of this presentation, have a clear idea of what your next steps are. If you are somebody who just wants to write your books, doesn't care, you know, and we have authors like that, don't care if they're pirated, don't care if they're, you know, any of that, doesn't bother them, that's absolutely fine. You don't need to do any of this at all. It's your choice. You're in charge. Some of our biggest author publishers see piracy as a marketing opportunity. So, you know, that's also a valid way to look at things. But I hope that you found this, those of you who are interested, and those of you, you know, we as an association, obviously there are ethical issues. I mean, ALLi's mission is ethics and excellence in self-publishing, and there are serious ethical issues here, you know, Maggie so eloquently referred to there at the beginning, the whole, you know, move fast, break things, apologize later, you know, don't care. And so it's the opposite to how it ought to be, really. And it needs authors, for those of you who do care, and for those of you who don't like what has been done here, please do get in touch. We are working hard in the background as well as bringing the information publicly. So if you have anything to contribute, or you just like to help to volunteer, we'd love to hear from you. Campaigns at allianceindependentauthors.org. That's great. So thank you, Maggie. Thank you, Catherine.
Thank you.
Thank you, Anna. And yes, that was really great. Take care now. Bye-bye.
Thanks so much.